Welcome back to For the Defense. I'm so excited to be back with you all after a pretty long break. 2022 was just an insane year. I was trying cases all over the place, 4 trials in 4 different district courts around the country. But 2023 started off with a little bit of a break as we get ready for the next wave of trials. So I wanted to get a bonus episode out to you. We're also preparing for season 5. We have an unbelievable set of guests coming up for season 5, which will probably come out towards the end of the summer or the fall. But in the meantime, I have this bonus episode with my good friend from Boston, Douglas Brooks. Doug Brooks is one of the great trial lawyers out in Boston, and he recently represented the Harvard fencing coach in one of the Varsity Blues offshoot cases. And you're going to hear some amazing stories about how he outmaneuvered the prosecution time and again, and won an acquittal in this case. We also did this interview as part of my white collar class at the University of Miami School of Law. So we'll go for about an hour with Doug talking about the trial and the ins and outs of the case. And then you're going to hear from some questions from my students as a little bit of a bonus after about an hour. So we're going to get to Doug Brooks in For the Defense next.
Peter Brand, a 70-year-old guy. He was born in Israel. His parents were Holocaust survivors, and they lived in a kibbutz. And for those of you who don't know, a kibbutz is a sort of like a small communal village. And he actually grew up in the Golan Heights. They sort of grew up in this area where there were regular battles between the Israeli and the Syrians. And he lived there until he was 13 years old. And then he moved to the United States. And he settled in the Boston area where I am. And he was an excellent fencer. After graduating college, he went into social work, and he was a social worker for over 34 years. And some of that overlapped. He went back into coaching fencing. And in 1999, he became the head coach of Harvard's fencing program. I don't know. I didn't know anything about fencing before this case. I still don't know that much, but, as the government said that it's basically sword fighting. And I guess that's correct, but there's a lot more to it than that, as I learned.
I saw that in their opening. They came out and said sword fighting. I mean, so how did is that what it is, or what? Tell us a little about what fencing is.
Yeah, I mean, yes. Although I think for those people that do it, that's probably a little disparaging. But there's 3 different types of weapons, and they all have different ways of scoring, and it's a team sport, but it's at the same time, it's all individual. So in a way, like a wrestling where there's a team, but at any given time, it's just one-on-one.
It is something that's great about the law, right? Like, especially criminal defense. Every case you get to learn a new industry, a new business, or in this case, fencing. I mean, there's really nothing else like it. I mean, as you say, you probably knew nothing about fencing before you came into this, and now you're an expert.
Right. Yeah. And in this case also sort of, I'd say, not just the fencing, but things that I really didn't know too much about that and actually even more relevant than the fencing is the college admissions process.
Right.
And in this case, especially at Harvard.
Right. Which I think is just fascinating. And, I got a flavor of it from the motions and the opening and closing. We'll get there in a minute. Let me ask you before we get there. So how do you get a case like this, a 70-year-old fencing coach at Harvard? You're a criminal defense lawyer. I always like asking my guests how they get cases, because when I started as a criminal defense lawyer, it's a mystery how you land a case. So how did you find this?
It's a great question, and every case sort of comes in differently. This one specifically, there's the sort of guy who's the sort of guru, Mr. Harvard fencing, is a very successful lawyer in Boston, a guy named Larry Citrullo, who is sort of our star witness in this case. And so well before the indictment in April 2019, the Boston Globe ran an article about this case. And so, Peter Brand turned to Mr. Citrullo for help because he knew him, through his Harvard fencing connections, but also knew that he was a successful lawyer. Because Mr. Citrullo was, sort of tied into Harvard, he and Harvard felt that there was a conflict in terms of representing Peter Brand in connection with Harvard's investigation. So he referred the case to me. And so at that point, I was representing Peter in connection, there wasn't a criminal case yet, but it was in connection with Harvard doing their own internal investigation. And this was in the wake of all of the so-called Varsity Blues cases, the college admissions scandal cases. So when this hit the Boston Globe, Harvard was in full panic mode that they were being that their admissions were being called into question.
And so did the Boston Globe article hit after some of the Varsity Blues indictments? Is that how?
Yes, exactly. It hit about 2 or 3 weeks later. Somebody who had heard about the sale of this house, apparently knowing about the Varsity Blues cases, thought that this might, be the same kind of thing and dropped a dime to the Boston Globe. And that's how all of this started.
And so, you get the case, Harvard's doing an investigation. Because of the Varsity Blues case, do you think, this is going to turn into something, or you just don't know at the beginning?
Yeah, I mean, at the time, that's the biggest issue because Harvard wants to speak to the client. The client wants to keep his job. And by Harvard, I mean, they hired outside lawyers to investigate. So if as a practical matter, if Peter decided, hey, I'm not going to cooperate at all, he's gone, right? Like they're not going to, just knowing how Harvard works, they're not going to keep him. So the first question you got to decide is, do I want my client talking to Harvard in a case that it might end up going criminal? And who knows how his words could be used against him then.
This is always the hardest issue in these cases. Before there's an indictment, you represent an employee, in this case, the coach. So do you let him get interviewed or you say no?
Yeah. So every case is different, right? And you don't know, and ultimately, of course, we advise our clients, but it's their call. And the other thing one thing for sure is you don't have all of the evidence that you will see at a criminal trial. So you're sort of relying on your client in a lot of ways to get it. I was in touch with the U.S. Attorney's Office, the prosecutors at that time about this matter because I knew that they had at least sent out a grand jury subpoena. At the time, they seemed very disinterested in it, which of course turned out not to be the case, but I think it was at the time. And so ultimately, a lot of factors, you could do a whole class on just that decision, but he did go in and meet with the attorneys for Harvard. And so
just out of curiosity, do those attorneys then give the interview over to the U.S. Attorney's Office at some point, or they hold on to it?
No, what they did here is they held on to, because they treat it as a privileged, they treat that as a privileged communication. Because in his role, it was in his role as a Harvard employee. So they kind of took a hybrid approach here. They did not turn that interview over or anything else that they did as part of their investigation, which, by the way, led to his firing. But what
the interview led to his firing?
It did lead to his firing. Not the interview per se, but the fact that it was sort of we'll get more into the facts, but the fact that it was undisputed that he took money from a parent, ultimately right. It led to his firing. But so those interviews, they agreed they were interviewed by the U.S. Attorney's Office, the lawyers that did that. That did the interview. They in turn were interviewed by the prosecutors, and they sort of gave the prosecutors a high level summary which we then saw through what's called a 302, which is an FBI interview report that the government turned over to us.
So your client goes in for an interview. At this point, he's not charged. Does the government call you and say, we're going to end up charging him? Do they just arrest him? What do they do?
Yeah, no, it kind of came out of the blue. So he wasn't arrested until a year and a half after that interview. So this wasn't fast moving. We did the interview, he got fired. I had a couple of calls with the U.S. Attorney's Office, where really what they asked they said, at some point they called and said, hey, we're still kind of poking around in this case. Does your client want to come in for a proffer? Which is where they would interview the client. There's some limited protections to the client and that kind of a thing. But then as we were weighing whether or not that was something we might want to do to potentially head off an indictment, they called back and said, if your client is going to take the position that he took with Harvard, that is that this wasn't a bribe, don't bother coming in here. We don't want to hear that. Basically, we only want to hear that it's a bribe, and we want him to snitch on the parent, gave the money.
And so you don't go in, and then do they call you back and say, please surrender him, or do they arrest him?
No. And there was a long gap between anything that happened. I mean, I had sort of was cautiously optimistic that it was dead. I mean, it was months and months, and I just assumed, well, they were hoping for something. They don't have the evidence, so they're not going to charge. And out of the blue, in I believe it was late November 2020, during the height of the pandemic, they went in and they arrested him
without a phone call or anything.
Without a phone call, again, you've got this guy at the time in his late 60s, sort of knows about no reason to believe that he would flee. I mean, just absolutely no reason to arrest him. And in fact, because it was the pandemic, they go and arrest him, and they don't try. They're not saying that he's a flight risk, really, because they didn't try to set any bail, at least any cash bail. So they let him out the same day, and the government didn't argue anyway. So it was really just for the sensational impact of arresting him. There was no reason to arrest him. They could have just asked him to come in and self-report.
Maybe they were nervous that the late 60-year-old man would use his swords or something.
That might have been it. That would be about the only. That would be more of a reasonable reason than they were able to muster. But
yeah, it's one of the things that drives me absolutely crazy in these white collar cases where there's no danger. They have all of the documents. There's no risk of anything being destroyed, and they just arrest. Really, it's to show the defendant what he's got coming in, and it drives me bananas.
Yeah, I couldn't agree more. I mean, I can tell you that the reason given in this district, in Massachusetts anyway, which still doesn't make sense, is that they think like that it would be sort of unfair to the non-white collar criminals that who do get arrested. But my point would be it's not really about every case should be looked at differently, and if the person is not a flight risk or a danger, there's no valid reason to arrest them. Especially in the white collar cases, most of the time. Even in this case where it came as a surprise, but I had been in touch with the U.S. Attorney's Office. They know he had counsel. They knew he would appear if they just asked him to. But anyway.
Yeah, so they have the same reason here in Miami as well, and maybe they should not arrest poor folks either.
Yeah.
So what is the government's theory? Last week, just so you know, we talked in class about typical wire fraud, mail fraud types of cases where there's some sort of property interest at stake. Here, I think the government concedes there's no property. It's more of an honest services theory. Yeah. So can you explain to the students, this honest services theory that the government's proceeding on?
Yeah, and they had two theories here. So first was honest services, which is this kind of, and it's been up, and there's actually a case now in the Supreme Court. It's one of these sort of, because it's so vague, it's kind of constantly being struck down in one form or another, but it's upheld. But the idea is that it doesn't rely on money. So the theory here was that Peter Brand deceived Harvard. The fraud was on Harvard because an employer has a right to expect the honest services of its employee. And that they said that by allegedly taking a bribe in exchange for his recruitment decision, recruiting these two young men, that deprived Harvard of its honest services. And what's important is the statute itself is a little vague, but I think it was in 2010, what the Supreme Court said was, look, it can't be the case. This wouldn't be constitutional if this could be violated, for instance, for violating a conflict of interest policy, right? It can't be that every single employment violation is going to violate the statute. So the Supreme Court.
I'd get fired from the University of Miami if that's the case. I mean,
yeah. So it has to be a bribe or a kickback. So that's kind of the one protection that you have, that defendant has under this statute. And the other, just quickly, the other charge here was federal programs bribery, and this also is kind of big. But so every university in the country gets federal funding. So because Harvard gets federal funding, if you take a bribe in connection with an official act that you make on behalf of Harvard, here the recruiting decision, you have arguably violated the federal programs bribery. So at the kind of the end of the day, we had made legal arguments that the judge sort of punted on, but what it came down to really, from the way it was pitched to the jury, was this is a bribe case, right? Under both of the charges, there has to be a bribe, and that's what you're here to basically decide.
So your case isn't technically a Varsity Blues case, I guess, because Rick Singer wasn't the cooperating witness, but it is the same theory as the other, 50 or so Varsity Blues cases?
Yes. So yeah, I mean, it is the same theory. There were slight differences. I mean, obviously the best fact we had, which they did not have in the vast majority of those cases, is that there were no allegations that Peter Brand lied about their fencing qualifications. In a lot of the other cases, the kids just didn't play the sports that they were supposed to have played.
Right. So I saw you guys, both you and the lawyer for the dad, stressed how qualified the two boys were. And it struck me, by the way, that they were there at the trial, which I thought was incredible. So can you tell us a little about the boys and their qualifications and sort of the admissions process at Harvard and why that was so important?
Yeah, so I'll say one thing in that. So we had done some jury research before the trial. And one thing that came out very disappointingly was that jurors, the fact that they were qualified for Harvard, that alone, just being qualified, didn't really help us that much, because the theory being that the jurors bought into the theory, like, okay, maybe they're qualified, but look, there's a lot of people that are qualified. And so they got this leg up maybe because of a bribe that wasn't good. So we really had to focus on the fact, truthfully, that when you take all of the various factors together, these kids weren't just qualified, they were no-brainers. So the way it works at Harvard is that you cannot get in there as an athletic recruit unless you're academically qualified. So you have to meet that bar. And for some of the sports, like football and hockey, you can be below like the average Harvard student and still get in. I mean, you have to have a decent academic record, but the average football SAT is not going to be the average SAT of the students at large. But that's really not true of fencing. I mean, fencing doesn't get any sort of pass. So they had to meet that, and then Peter Brand's allowed to recruit 6 students a year, combined men and women. And so the government really hadn't done its homework. And they seem to have this theory that like anybody who's a top fencer would love to get into Harvard. Why not? Right? It's Harvard. Why wouldn't anybody want to get in there? But what they really didn't understand until the trial was that of all of the top fencers in the country, first of all, not all of them are going to be qualified to get into Harvard. And what they also missed was that a lot of students, a lot of good fencers, even if they are qualified to get into Harvard, they don't want to go to Harvard because they're going to have to pay for it. And they can get full scholarships to top fencing programs, better rated than Harvard, at schools like Notre Dame, Ohio State, Penn State, so very good schools. So again, the government had this theory. These kids the Zhao boys were ranked, somewhere between like 15 and 17 in the country. And the government's theory was, well, that's good, but he should have recruited somebody higher. But they really didn't understand how the process worked because they didn't look into it.
But it's not just that they were, top 15, 17 in the country. They were also, their backgrounds were incredible. Oh,
they were the highest academically rated in their classes. I mean, they had like 1,600 in the recruiting class. They had like 1,600 SATs, straight A's from one of the top, prep schools in the country, all sorts of extracurriculars. And the other thing that was very important to Peter Brand when he's recruiting them is that a lot of top high school fencers use it as a vehicle to get into a top school, and then they quit fencing. And there's no repercussions because there's no scholarships at a school like at any of the Ivy League schools. So if you quit, you just get to stay on. So these two young men were like really passionate about fencing, and they had committed to him, and he believed him that they would fence all 4 years, which he did. And again, that's one of the things that the government just didn't do because they really didn't interview people in the fencing world that understood how it worked.
The other fascinating thing to me that I saw from your case is that Harvard encourages coaches like your client to sort of go after the rich parents, kids with rich parents. Can you talk a little about that?
Well, yeah, this was a huge dispute at the trial because Harvard, I mean, that was just, from what we knew from the people we talked to, that was so clear, and we just thought it was going to be undisputed. Harvard had its witnesses prepped to say the exact opposite. The one, they ended up only calling one person, although they had a lot more on the witness list. The government called a person in the admissions who said that, he wouldn't even be aware, like that the wealth of a family was not something that was considered by admissions, which is just an absolute lie. And we had a witness who came on the stand who's, again, it's this guy, Larry Citrullo, who's been affiliated with Harvard for 50 years, who said it's a free-flowing conversation within admissions. It's absolutely known who has money.
So in terms of whether Harvard lost anything, we'll put aside the honest services for a second. They got tuition, they got great students, they got great fencers. I mean, it's hard to make Harvard out to be a victim here, it seems like.
Yeah, and yes, I mean, which was another great fact for us. And again, I don't think going into the trial, the government, I think they understood our defense, but I don't think they really understood all of it. And so, but that's one of the holes in the government's case. Now, the judge ruled before the trial that legally Harvard didn't need to be a financial victim. But it's, from the point of view of a jury, the case loses a lot of its appeal when there's no victim. And here, not only was Harvard not a victim, we argued that they gained a lot from these two young men, not just because they got straight A's at Harvard and fenced all 4 years, but because Harvard, not surprisingly, hit up the family for hundreds of thousands of dollars in donations on top of the full tuition that they paid.
you're obviously based in Boston. This was a Boston case with Boston prosecutors, but it seemed just from reading some of the transcripts, like you could feel the tension and how heated it was. Was I reading that right? Was it heated between the defense and the government throughout the case?
Yes. And actually, really before the case, we rightfully accused them of fabricating evidence, which they did. So one of the things that they wanted in, there was a big fight over, they wanted in the fact that our client violated Harvard's conflict of interest policy, which is why he got fired for taking money from a parent. And we argued that, look, that's irrelevant because it doesn't matter whether he violated a conflict of interest policy. It just matters whether it was a bribe. But in any event, what we accused the government of before the trial, they had taken these two separate documents and the way that they had produced them to us in different periods of time through some, shenanigans, they attached them as one exhibit, as if the conflict of interest was attached to this other thing that he signed. And that's not the way it had been produced by Harvard. And we only kind of found out about that through happenstance. So we filed a motion, accusing the government of misconduct.
So obviously that raises the temperature quite a bit, and you could just see in trial. I mean, from reading some of these transcripts, you guys were going at it. Let me ask. So in these Varsity Blues cases, your case, Roy Black's case, one other case, those were the only cases that went to trial. Everybody else pleaded. And when you speak to some of the lawyers about why, they say, listen, the risks were just too great. If we go to trial and lose, one of these Boston judges might put us, there was one apparently bad or tough sentencer judge. If you're in front of that judge and you lose a trial, you're going to go to jail for years.
Yep.
And so, the risk is too great. Were you in front of a judge that would have been a tough sentencer? I don't know how much you could say about that.
Yeah, no, I could say, so he's not as much as the one that all of the original cases were drawn to. He's sort of known as the toughest sentencer in this district. Our judge is known as, I'd say sort of, down the middle, leans government, very much sort of a, super nice guy, as we say, lets you try your case.
Yeah.
But had it not gone our way, this would have been a sentence. There's no way it would have been less than a year.
So you have
would have been a real time in prison.
Right. You have a 7-year-old guy with cooperation against the dad, probably does no jail time or little jail. I mean, those are always such difficult decisions and conversations. And I don't know, again, how much you can say about this, but was Coach ever interested in doing that, or he was always trial full steam ahead?
So it's funny, somewhere in between. So he actually, I think I'd say this, I mean, he didn't want, when this first happened, he didn't want to try the case. He just thought it was going to be so hard on him and his family. He sort of just wanted to be done with it. But when it kind of became clear that the only way that he would get a better deal sort of before trial than afterwards, at least in any meaningful way, would be to cooperate against the dad. And look, Peter was steadfast. He just said, look, this wasn't a bribe. Even if I wanted to, I can't cooperate because they want me to say it's a bribe. It wasn't a bribe.
It's really interesting. So with all these Varsity Blues cases, I guess there was 50 some odd. I mean, if all of them had gone to trial, let's say, you would expect some percentage would have been acquitted. And yet, almost all of them to a T pled, including, famous defendants like Lori Loughlin. And now there's this case before the First Circuit, which the Court of Appeals looks like they're skeptical of the whole theory in general, and they may reverse. Any predictions on what the First Circuit might do there?
Yeah, they're almost definitely reversing. And I think just the issue is, what's the fallout when they reverse? Like what is is there going to be a retrial? What does it look like? But yeah, so only 4 of these cases have gone to trial. So the first one, the two parents were convicted, and that looks like it's going to be reversed and probably there'll be a retrial. Then there was a conviction of a coach, but that's been overturned. That was overturned by the trial judge, and now that's going to go on appeal. And then the other two, ours and the one that Roy Black did, the Corey case, ended up in acquittals. So it's kind of these cases have lost a lot of their luster, right?
Right. I mean, the government charges these cases to huge publicity, articles, news, Netflix stories, and like a lot of these other white collar cases end up sort of fizzling out at the end of the day. But yet, almost everybody pleads guilty. The system seems warped.
You're right. You've got these. I mean, it's a very tough system, and in these cases, the government was very heavy-handed with especially in high-profile cases. That's what happens. They indict these cases to great fanfare. They know they're going to make a name for themselves, right? I mean, it's not just local news; it's international news. And they do it. And, the public is initially outraged because of how it sounds, but then people start poking around and it's like, you know what? Some of these legal theories may not hold up. Like in the court of public opinion, people were upset that there's, this is what's going on. And then, they were very heavy handed. I mean, they basically told people in terms of pleading, like, hey, we'll agree to this sort of sentence, something very light. And if you don't agree, not only is it off the table, but we're going to add all of these charges. In one case, they're, sort of thinly veiled threats that, okay, we'll indict your kids, the kids that participated in this, at least the ones that knew about it. And so there were things like that. So, kind of, you're right. Like what, it just seems like, why do I want to go through all of this when I can just plead and get it over with?
I actually felt bad for the kids in your case and in a lot of these cases. I mean, these are good kids who did great in school, worked their asses off, did great in college. And, they now have to live with this the rest of their life.
Yeah. And that was obviously, we made that a major theme in our case. And again, we had, our kids were really like off the charts good, right. which was a great fact for us. They testified at trial. And they were our last two witnesses for the defense, and they were great witnesses. But yeah, we made that point. In my opening, I started the case off by trying to compare the punishment that these kids are going under versus the punishment that the government's cooperator, which was none, is going under, even though he had admitted to all sorts of unrelated crimes.
I love that you came out swinging in the opening, especially against the snitch. And made it a lot about him. And that was slightly different, I think, than the dad's strategy in his opening. Did you work closely with the co-defendant, or were you guys sort of on separate teams?
No, we worked very close. We had a great relationship with them. And I didn't really know that. I knew of them. I didn't really know the two lawyers, Bill Weinreb and Mike Packard, before this case. Bill Weinreb actually was sort of, when this all started, had only recently left. He had been a prosecutor. He only had recently left the office. He'd been the acting U.S. attorney. So I kind of didn't know what to expect. But they were very easy to deal with. We obviously had, in some ways separate issues, but with the bribe case, look, sort of theoretically, one person could be guilty and one could be not guilty. But if it's a true bribe, right, there's one person is giving the bribe, one is not.
Right.
And so we worked great together to make sure we weren't shooting at each other. I will say it was to everybody's advantage, but it was especially to our advantage because, frankly, the evidence was much worse against our client than it was against the dad, the co-defendant.
Let me ask you one bit of trial things that happen in trial that you can't prepare for. And I read this at opening and I smiled. I saw, you had your PowerPoint or whatever set up and it didn't work. So, we all have nightmares about this. So tell me what happened and how you dealt with it.
Yeah, well, it ended up, okay. So, I mean, I've always said, I don't know how you feel, David, but I I hate the whole exhibit piece. Like, I don't want to have anything to do with it. Like, it's in the old days before it was all electronic. Like, I just feel like that's the stuff that keeps me up at night, not the opening statement, not the examinations, like just, in the old days, setting up the easel and having it fall, like things like that. So this is all, in the federal court now, everything's electronic. So there's a screen, all the jurors can see it. It goes. So I start talking, and I didn't have a huge one, but I had, slides to go with my opening, and it wasn't working. And so I said, yeah, that's what I said during my right. And so I started to, I just blew by it. Fortunately, my paralegal, who's a lot smarter than I am, from the back of the courtroom sussed out the problem and came up to counsel table and fixed it. So it ended up working. The bigger surprise, though, and this was way worse, and this doesn't show up in the transcript for whatever reason, I guess because it was just not talk. So I had well choreographed that I wanted the jury to see the client's wife and kids, that they were there, kind of important, humanize them. This is a guy, this isn't the monster that the government is portraying. And I'd spoken with the family, explained how it was going to work. And when I went to introduce the wife, I said, his wife's here and nobody stands. And I said it like 3 more times. And it turns out that my client's wife had chosen the beginning of my opening to go to the restroom.
Oh, no.
So it was this awful, and I mean, that was way worse than the PowerPoint, because I was just standing there and it was just so awful for so many different reasons. But I will say this, one of the things, I mean, there, a few things like that happen. And I think like early on in my career, I probably just would have been a wet puddle when that happened. I just wouldn't have, but you kind of learn that you've just got to go on.
Yeah.
And you've got to act in front of the jury like it doesn't matter, because the jury's looking, especially early in the trial, they don't know you from anything. And if they see kind of like, you don't want to perceive any weakness, and you want to show that no matter how bad something looks, it's not bothering me, right? It's not going to the ultimate issue of my client's guilt or innocence. So you've just kind of got to roll with it. And I think that's something that just comes with experience.
So when she comes back in, do you say, there she is, or what happens?
No, I didn't. The courtroom was so packed. They had an overflow, because this was, I didn't even see her. I didn't see her come back in. I had a stern conversation with her out in the hallway after.
So, I bet she felt so bad. So one of the things I saw that happened in opening is, the theory was this wasn't a bribe, this was a loan, and it gets paid back. And the government at the end of the day freaks out, says, we don't know, we weren't told about this, we didn't get any documents. How does that play out? Are they able to keep out the documents, and what happens with loan arguments?
Yeah. So this was like the best, right? So one of the things that happened after indictment, but before the trial, was that my client's mother passed away, and he received his inheritance. And it had always been his contention that the understanding was that he would pay the father back with his inheritance. And so that happened. And so we assumed, and the government was on notice of that, because that's what he told Harvard. Okay. So this wasn't like something that was made up after the fact. So we assumed Harvard would look into this and the government would look into it and figure it out. But as discovery was going on, the defense lawyers were all talking to each other and saying, they may not realize this. So he did make the payment. And then when it came time for us to provide reciprocal discovery, and the rule is, if you're going to use something in your case in chief, you need to produce it. So if we wanted to show the check as an exhibit, we wanted the jury to see the check, we would have had to produce it to the government. But what we did was, we strategically, the defense lawyers got together and said, how awesome would it be if the government opens on a theory that these were bribes and fails to mention to the jury that they were paid back because they don't know. And so we decided we're not going to give them the check. And the risk is that we can't use the check as affirmative evidence, but it doesn't mean we can have people testify about it. And it had already been determined that the wives were going to testify. And especially our wife was necessary because she touched every single aspect of the case. So the government basically freaked out because they thought they were hiding this. And, we just explained to the judge, look, we know our obligations. We're not looking to introduce any documents. We want to prove it through testimony. And the government sort of didn't see that coming. And when the judge looked at them and said, well, what's your response to that? They kind of stammered and said, well, if that's what they're going to do, I guess they're allowed to do it. And then so I think the best part was, and this is kind of an evidentiary thing, but so when I called my client's wife and she testified about paying it back, and I think the jury believed her, but just to kind of have the extra evidence, even though we couldn't show the check, I asked her what was the exact amount down to the penny that she paid back. And she said, I can't remember. And I said, well, is there anything that would refresh your recollection? And she said, yes, if I could see a copy of the check that I wrote, I would know the exact amount. And so the jury didn't see it, but they understood. I said, okay, let's show Miss Phillips the copy of the check that she wrote that she and her husband wrote to Mr. Brown. And so it's at the end of the day, and I've always thought that sometimes people put too much emphasis on, they think every single piece of evidence has to be attached to a document, but that's not the case. I mean, this was clear. What is the jury now knows there is a check. We're not seeing it, but the government can't argue it doesn't exist. So it's sort of undisputed that it exists.
What a great moment and what a great piece of trial strategy. I love hearing stories like that. Amazing. So let me ask you this. The wives testified, the kids testified. Did the clients testify? And what was that like trying to make that decision?
They didn't. Always a tough decision. And David, I know you and I have talked about this. And I think you and I sort of fall on the side of some people think that a criminal defendant should never testify.
Right.
I don't agree with that at all. I think that no matter how many instructions you get, a jury wants to hear from the defendants. I know they did in this case. I thought that was, going to be the biggest problem we had. I mean, without getting into too much of the details, this case took a huge toll on my client. And, again, he's not old, but he's, not a young guy. And we just felt that his memory was such, his recall of events was such that I don't think he would have been a good witness. And we were only going to put him on, frankly, if we felt that this case is lost and we might as well, kind of throw a Hail Mary. And we felt we still had a fighting chance, so we didn't put him up.
And your co-defendants' children, those boys, when they testify, I mean, what's the cross of them? What does the government do with those two boys?
So the government was actually pretty smart and they didn't go after them hard. What they did was, I think, kind of the classic thing that you do when a defendant calls witnesses and you're not really challenging their credibility. The government just kind of used them to remind the jury of their case. Like, showing out, well, the boys, you didn't know that your dad was, was making these payments to Coach Brand, whether they're loans or not. Didn't know that he bought his house, like all of those kind of things. The mistake the government made, because I actually thought that they had the right tone on those crosses. They didn't really go after the kids. But throughout the trial, the government opened up on the fact that this isn't about the boys. The boys did nothing wrong, whatever. But they couldn't help themselves. And so the younger son ended up not having as good a fencing career as the older. So he fenced all 4 years, but wasn't a regular starter, blah, blah, blah. And the government, even though they kept saying they weren't going to go after the kids, the government did attack the younger son's credentials, which was a mistake, one, because I don't think the jury liked it. And then two, it allowed us to get in all of this like kind of other stuff to rebut how good he was that otherwise might have been irrelevant, and just kind of bolstered the younger son. And the younger son was actually one of the best witnesses I've ever seen. You know, he had all of this personality. And I think the jury really did not like the fact that the government was taking shots at him because he wasn't a starter, you know?
Really good stuff. Real quick about the closing. I saw in the closing, you know, the government was stressing that your clients needed money, and they talked about some of these documents that are way old, emails between your client and his wife. And I love when you talk about the slow cooker email and how that's not an email about desperation. Can you tell us?
Yeah, well, and this is actually another piece of strategy. I think you'll like it. I mean, so the government's kind of theory of motive was that my client was in, you know, desperate financial situation. They had a handful of emails with the wife. And I mean, I knew the government was relying heavily on this because they littered the indictment with it. And I also knew it kind of had some public appeal because it was all over the Boston Globe articles about the case.
Right.
We filed a motion in limine to keep those out. And I told everybody at my firm, I'm like, look, we you know, for the record, we got to do this. I said, and co-defendants really wanted to, but I was telling everyone in my firm, I said, I hope we lose this. I said, because I think we can use this against the government. And everyone in my firm's like, you're crazy. These are like the worst text messages and emails I've ever seen. She's talking about how they have no money. And my client's wife, even, which was freaking out about them, about having to testify about them. And I said, don't worry, we're going to have fun with these. Because I realized at the end of the day that people on the jury are going to have these same conversations with their husbands and wives. These were not like bribe emails. These were just people who from time to time, you know, had an overdraft in their checking account.
Right.
And sure enough, with that whole slow cooker thing, that came up first on cross-examination. And the reason I brought it back on closing was the jury was cracking up when that was an email that the government showed my client's wife on cross, and on redirect, I spent about 5 minutes on the slow cooker, and the jury was dying laughing. So I knew to bring that back and just to sort of poke holes in, like, this is the motive. It's ridiculous.
So the jury's laughing with you. Must feel good. The jury goes out. How long are they out?
So they were out. It was just the same day. They went out about, I think they deliberated. They got in the morning. So they deliberated somewhere between 5 and 6 hours.
It's the worst, right? When the jury's out.
There's no worse of a feeling. And then when you get we're all just kind of hanging out in the lobby, right? And right by the courtroom. And all of a sudden the clerk comes out and says there's a verdict. And I mean, I don't know about you, my heart's pounding about 8,000 beats, right, per minute. And so we go there. And of course, at this point, you start, you know, I'm kind of telling the client, look, if it doesn't go our way, just, you know, keep your composure. We're going to keep fighting, all of that. And you realize the client had been pretty stoic throughout, but you can see he's really, at this point, obviously very nervous. And then what happens is in our courthouse, the U.S. Attorney's office is in the same building, and they get word of it. And the entire U.S. Attorney's office, there had to be 70, 80 people file into the courtroom, standing room only, to watch the verdict. And what happens is when you get news that there's a verdict, especially when you're standing right outside the courtroom, before the judge and the jury come into the room, you're there for about 10 minutes, right? It's the worst 10 minutes of your life. But behind me, and I couldn't even look back, the courtroom is full. So it's, you know, client's family and then about 70 assistant United States attorneys. And it's a total party atmosphere for them, right? Totally clueless that people's lives are hanging in the balance. They assume, you know, they're going to get a guilty, and there's all this laughter, and they're just all joking around until the jury comes in. And so it was kind of extra sweet to see them all slink out of the courtroom when it was over.
I was about to say, they slinked right out of that courtroom.
They were gone. They were gone by the time I turned around. There was nobody left.
In one of my first trials, I had the same conversation with my client. no matter what, keep a poker face. If we lose, poker face. If we win, poker face. We got to stay professional. And the jury came back not guilty, and I jumped out of my seat up, and there was press who took my picture, and the client looking up at me was like a bewildered look because I had keep a poker face. So do you get to speak to the jurors after, or no?
They don't do that in this district, so you don't. And if you want, and it's so tight here. I know it's different in other places. You don't get to speak to the jury. And if you want to go speak to them even afterwards, you need court permission. So it's not like it is in other places. I'm definitely curious. I'm very curious to kind of know, you'd love, because you always want to know, right? I mean, we tried a bunch of things, and for the next trial, what worked, what didn't, it's probably different than I think.
You should be able to talk to the jurors. I never understood. There's that rule in the district. So last question for me, and then I'm going to turn it over to my students, which is, tell us about the celebration afterwards, what you guys do. Did you savor it? And tell us a little about that.
Well, it was perfect, right? Because, so the trial went 3 weeks, and at least a month before that, it's sort of you're working 24/7 on the case. And so this verdict came in late in the day. I think it was December 21st. So, right, the timing couldn't have been any better, right into the holidays. So that night, my client went home for his own family celebration. I'm at a small firm. Basically, the whole firm went out and celebrated, and then later we had a nice celebration dinner, with the client.
Do you get free fencing lessons now, or?
Well, what he gave me as a token of his appreciation. So I have a championship ring, Ivy League championship ring.
Very cool.
Which is a good kind of memento from the case.
I hope you enjoyed that episode as much as I did. I had a lot of fun with my old friend Doug, and hearing those trial tactics about how he got in the defense without putting in the documents and then reference a document. I thought that was really, really neat. How the prosecutors had to slink out at the end of the trial. Just great stuff. Now we'll turn to some questions from my students at the law school, which I think you'll enjoy. Thanks again to Doug, and we'll be back soon with another episode of For the Defense.
My name is Alex. My question for you is, I was looking over the indictment and the memo that the defense prepared, and it seems like on the face of the case that it's not immediately clear why this is a federal crime. And you would think that federal prosecutors have better things to do than prosecute something like this when people are being murdered and people are being sex trafficked. So can you explain a little bit more about why, according to federal law, this was a federal crime? Was it because by accepting this bribe and by Harvard giving scholarship money to fencers that they were using the federal government's grants, or it was kind of like stealing from the federal government? What exactly?
Yeah, Alex, it's a great question. It actually kind of goes into one of our themes of the case. But so for the two things, so for honest services, the reason that the federal hook is it's what's called honest services wire fraud. But basically everything, interstate wires, but basically everything these days constitutes that. So the actual jurisdictional hook was that my client submitted these recruiting forms via email, and that's using wire. So that's the hook. On the federal programs bribery, it's not even as sort of tied in as you might have assumed. So it had the funds at issue had nothing to do with federal funds, but because Harvard receives more than $10,000 a year in federal funds, and again, this applies to basically every school in the country, any agent of Harvard who makes what they call an official act, and in this case, the official act was submitting his recruiting form, that becomes a federal, a violation of this federal statute, 18 USC 666 federal program.
Even though there were no lies on the form itself, right? I mean, did the government, there were any lies on the actual form?
No lies, no lies on the form, but the government's theory is even though the form itself was truthful, it was kind of the fruits of an illegal bribe. And so, but you're right, Alex, like there is what we haven't talked about. There were some very, 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 very damning texts and emails that my client sent, which is, which is why the case got indicted. But we figured that a lot of jurors are going to think exactly what you just thought, which is sort of, why are we here? So we were hoping that, like, what I always said, when we were kind of preparing for the case was, look, I'm not sure, maybe if we're lucky, we can convince every juror that this wasn't a bribe, but I at least want to be able to I want jurors on this jury who think, but even if this was a bribe, he did what he would have done anyway. And kind of, why are we here? Why are you wasting our time? And, again, without talking to the jury, I don't know, but I think it was probably some combination of those.
All right, great. Thank you.
Thank you so much.
Thanks, Alex.
All right, we got another student. Tell us your name. And we have, this is a special one because she worked on another one of these cases. So go ahead.
Yeah, I actually worked, when you were just talking about the whole stat 666, I worked on research about defining what benefits are under that statute. So I was working on the Corey case, the Georgetown case. So whether if you're receiving grants as under Pell Grants, if that's how the government is defining receiving federal funds, is that really for students versus the school and everything like that, which would have been a great appeal, but thankfully we didn't have to go that way. So it was all good. But actually my question was looking at your case versus the dad's case you were saying before about how your client obviously had kind of voiced facts in his situation. So I was just wondering if you could talk about how you developed your theory of the case.
Yeah. And by the way, it's really interesting about those Pell Grants, because we did a jury instruction basically saying that Pell Grants aren't enough. And so the government had to scramble. We were going to they wanted us to stipulate to that element. And then the government went out and found a lot of other non-Pell Grant money that Harvard got, which kind of killed the Pell Grant argument for us. But yeah, so look, the clearly we had some good facts, but the worst facts for us were that my client sent a lot of texts to the cooperating witness or snitch, whatever you want to call him, that just look awful, right? It looks it's like he took the federal bribery statute and cut and pasted it into some of these texts. And so that, obviously you're not going to have a federal trial if all the facts in that situation. So, what we really did was we tried to put those into context and say that, because like everything else, these were texts. They weren't long things. It was sort of, so we made the argument that, look, the government's taking these out of context. When he's talking about financial support, he's not talking about personal financial support. He's talking about support for the program. And we were able to elicit a lot of evidence that he was under incredible amounts of pressure to raise money. So that rang true. And some of the language he used in those text messages that sounded just so awful, we were able to show that he used the same language in innocent emails, years earlier. So there was that piece. And then, in my closing, what I tried to relate to the jury, which I think is relatable to most people, is, look, when you throw up these 3 or 4 text messages and you put them together, they look horrible. But that's kind of not the way the real world works. And imagine, in this day and age when everybody is just texting or, some kind of messaging constantly, imagine being on a criminal trial, and having the government just pull out, 4 text messages of who knows how many thousands that you've sent and being judged on those. And there were a few in our case where when we kind of made the point about, look, he's using this innocently in other contexts, the government would point out, well, look, the wording is a little bit different. They would do that on cross-examination. So I also pointed out that, imagine that being done, and then imagine that these text messages aren't being sent in your first language. And my client is fluent. Look, he's been here for over 50 years, but a lot of times, no matter what, when a language isn't your first language, even when you're fluent, you're not quite perfect. And I can attest, frankly, that's the case with my client. So that's kind of how we got around that particular issue. Now, the one thing, as I said, we worked really closely with co-defendants. And so we tried to be very respectful of each other's defenses, but in their closing, and this just felt like a stab in the heart. I understand why they did it, but the dad's defense lawyer pointed out to the jury that there weren't any text messages from his client that they saw. And, you're just sitting there thinking, especially because I think a lot of juries, there's a natural human tendency to want to split the baby, in one way or another. How do we kind of find a compromise solution? And so I was terrified that the compromise solution would be not guilty to the father and guilty for the coach.
That would be, there's nothing worse than that. I mean, nothing worse. So
right. I mean, that would just be right. Everyone's thinking well, the other guy won. Why did you lose?
Why you suck, Brooks.
Why are you the worst lawyer in the world? How could you lose that?
Right. All right.
And that was a real possibility here, David. I mean, that, I didn't, that was one, I didn't want to voice to people, but that did keep me up at night because I thought that was a real possibility. And I'll say in the jury research we did beforehand, and they don't hear the whole case. So it's always, but the father came off as much more sympathetic than our client did.
Right.
But I think we were able to change that at a trial and they were equal. So.
Hi, Mr. Brooks. My name is Mitch Leheim. You touched on it a little bit earlier about after your client was indicted in the meeting you kind of had to decide whether to take it to trial. I'm just curious about your strategy in those type of meetings when you're advising a client where, like you talked about, the court of public opinion was very much, I'm sure, against him at the time.
Yeah.
That conviction that this wasn't a bribe at all. But were there other motivating factors in that advisement and just normally how you go into a meeting like that?
Yeah, those are really tough meetings. And, they're just, you're kind of, laying it out. I mean, it's probably kind of a boring answer, but the key to a meeting like that is you just need to be so truthful and transparent with the client. And you need to explain to them sort of every step along the way, sort of okay, here's what a trial is going to look like. Here's what here's what's going to happen. Here are the risks, here are the potential rewards. Here's what's likely to happen if you, if you plead guilty. Here's, what sentence you're likely to be looking at before and after a trial. And again, in this case, it ended up being a little bit easier than in a lot of cases because when he found out that the only way that he could really get a good quote deal would be to admit that he did what the government was saying and cooperate against the co-defendant, he just said, well, that's easy. It didn't happen. I can't do that. I'd be lying. And so it's kind of that's a lot easier than it is, in a lot of other cases.
Makes it much easier when the client's like that. Thank you. All right, we got another question coming.
Hi. So I was hoping to talk about the jury selection process and what you were looking for there versus what you were trying to avoid. How many people did you have to strike to get what you were looking for?
Yeah. So this varies by district and it varies by judge, but our judge basically said, this is not a complicated case. You're not getting basically any information about these jurors other than the standard questions. We had filed a motion for a jury questionnaire with all these questions. We want as much information about the jury as possible. And this judge said, nope. And he basically, we had very little. So there are the standard questions. So what we were looking for, and it's more art than science, but we were looking for, and again, some of it was based on research, but a lot of it was based on, we were looking for more blue collar jurors because we had the sense that blue collar jurors aren't going to view this as their crime and they're not going to care about Harvard. Harvard's kind of a huge employer and that kind of thing around here. So it's a big name. we didn't want anyone affiliated with Harvard because we didn't know. And we were sort of told by some of the jury consultants that, in a perfect world, you don't want anyone who has kids around the college admissions age, because there's going to be this kind of, well, maybe they took my spot. But what was really interesting was that because these kids were qualified, there was this kind of weird role reversal. So during the way it works in this trial was the judge asked, there's like 80 jurors sitting in the courtroom, 80 potential jurors. And the judge asked certain questions. And if the answer was yes, they'd raise their hand and it would show some potential bias. And then when that process was done, he'd call them all up to sidebar and ask a few questions. And then you could either challenge them for cause or exercise one of the peremptory challenges to get them off the jury. And this one juror came up and she said, I don't think I can be fair because I'm a Division I athlete and I used to practice next to the fencing school at my team. And I saw how hard those kids work. And like these cases, they make me sick. And so obviously what she's saying is I can't be fair to the defense. But the 4 defense lawyers who were up at the sidebar, 2 for each client, we're looking at each other and we're all thinking the same thing, which is, oh my God, when she hears the evidence about how hard these 2 kids worked, she's going to be on our side. So we're all kind of looking at each other like to try to get each other's attention, like don't challenge this juror, which would be the natural thing to do. Yes. And sure enough, as soon as she sat down, the government says we moved to strike her for cause. Wow. So it was this kind of crazy thing where it's like she's basically saying, I can't be fair to the defendants, and we wanted her and the government didn't. And the judge struck her for cause. We were so mad, but the judge struck her for cause. So they didn't even have to waste a peremptory on her. So
really interesting. Thank you. All right. So we have 3 more groups of people. We'll go here, and then here, and then we'll turn it to we'll go back to class. So thanks, Doug, for giving us all this time. We have 3 more questions for you.
Hi, my name is Jared. I appreciate you being here with us today. I just want to ask a little bit about the bribe versus loan situation. I know you mentioned the check and testimony. First of all, did the check predate any investigation into your client? And secondly, did any documents, whether it be texts or emails, exist between your client and the parent that said this was a loan, or did that just not exist?
Yeah, no, great question. So no, the check predated trial, but postdated the charges. So we knew that this would only get us so far, right? Because the government could say, look, isn't that convenient? Now, he had told Harvard about this beforehand. So then, the second piece, you're seeing kind of why the payback was helpful, but it wasn't the end all be all, because there was nothing in writing memorializing this. So there was no loan documentation and there were no texts or emails between the clients. And fortunately, we had evidence of the co-defendant's generosity and the fact that he had loaned money to friends before without any documentation. Or in one case, there was documentation, but the guy said, and the person testified said that he loaned money to, said there was only documentation because I asked for it. The government fought like hell to keep out evidence of his other, past generosity. And it was one of the, 2 or 3 most hotly contested issues at the trial. The judge actually took a break for about 2 hours in the middle of a trial day, researched the issue and came back and said, we can get it in. He let in about 90% of it, I'd say. And that was huge because it was sort of the one piece of evidence that showed, okay, well, maybe it was, maybe there is something to this. And there was also some testimony. So that the co-defendant was originally from China, now an American citizen, but there was some testimony from a couple of witnesses that this was, sort of a Chinese cultural thing, that if a friend asked you to loan him money and you say no, it's sort of an insult. And
All right, that was great. Thanks. So we have two more. Are you guys together? You want to? No, separate.
Yes.
Okay, so we have three more questions then. All right, one, and then we'll finish up. Thanks, Doug.
Hi. I wanted to ask about your trial strategy with some more of the bad acts that they had alleged in the indictment. Because they were saying in the indictment that, the co-defendant, Mr. Zhao, was paying off car loans and student loans and tuition, paid for the condominium, paid for the house. What was your strategy in explaining some of these, what seemed like very bad facts?
yeah, well, and they were bad facts. So there were three, sort of one of the just worst facts at all is there were three types of bribes that the government alleged. And so the problem was, it's sort of like we had an answer for all of them, but I was very worried that it would start to feel like, you've got an answer for everything, but it's all kind of, yeah. So the first was the foundation, if you saw anything about that there was this kind of foundation to foundation loan. And we just had great facts on that. The fact that our client never, they didn't pocket any money. So our theory on that, the government's theory on that, this is a mistake, and you've got to hold, opposing counsel to things like this. The government in its opening said the reason that my client set up a foundation to, quote, accept the bribe was that there would be no fingerprints, which was a huge mistake because we were able to show that because of the foundation, everything was documented. So there were so many fingerprints, and it was great. Got to use that, just hammer the government on that in closing to make it look like they didn't know what they were talking about. All of those payments, other than the house, that was a separate one, but all of the mortgage payments, et cetera. So the theory was these were loans, and it was made to effectively help clear up my client's financial situation, his balance sheet, so that they could go, get a mortgage and buy a condominium in Cambridge, which they were looking to do. And, what we did was it just sort of, one of the theories was don't fight it. Look, these payments happened. We have to embrace it in front of a jury. And again, we got I think we got a break because the loan stuff, as I mentioned the last question, it only got us so far because the loan was repaid after he was charged and there was no documentation. So it was definitely something that you could see. Not everybody's going to believe that. But the best thing that happened to us is the government not doing their homework and not knowing that it had been paid back. So what we argued to the jury was they're hiding that from you, right? The government doesn't want you to know about this. Why doesn't the government want you to know all of the facts? So again, I think on that, the best we could do was, look, this was a loan payment. It's all been paid back. Even if you don't, even if you don't like it. And I did a lot of that point too, and everything, because I knew some of the jurors just aren't going to like the fact that there's a financial transaction between the government and so said, look, this was paid back, kind of a no harm, no foul. The worst though, I felt very good about the foundation, and I felt pretty good about the loans. The house was the hardest piece because there's just no doubt that he paid too much for the house. And like in this day and age with Zillow and all that, it just feels like it's so easy not to overpay. And, we had looked into it. Is there any argument he didn't overpay? And there was none under the circumstances. But I will say another thing that helped here is, again, the government kind of overshot. So, and sorry if this is taking so long, but this is kind of the overarching of the case. So one of my favorite moments at the trial was the government called the Needham town. That's the town where this happened in, which coincidentally is where I grew up. So I know the town very well. And they called the Needham town assessor. And he should have been a brutal witness for us, because in real time, back in 2016, his notes reflect that the house sale made no sense. So he wasn't looking at it after the fact. He said this guy overpaid for it. And so the theory at the trial was, look, he overpaid for it, but it was just because, people didn't do their due diligence. Our client had this old appraisal, and if you use that appraisal, you know, you'd get to the $1 million that he paid. But again, it was definitely the weakest part of our case. But this guy gets up on the stand, and to try to show how allegedly bad shape the house was in, he says, "Oh my God, I remember this. And I remember walking in, and I thought the overhang above the front doorstep was going to fall down and kill me." And so I went during cross-examination, I didn't really have much to cross this guy on until he said that. And I said, you know, Miss blah, blah, blah. I said, you seem to have a very vivid recollection of this porch thing. Yeah. And I said, and you, just be clear, this was during an inspection that you did 7 years ago in 2016, right? And he said, yeah. And I said, but you have such a vivid recollection. And he was so proud of himself. He said, "Oh, well, you know, Mr. Brooks, if you had something as dangerous as a porch overhang almost falling down on your head and killing you, you'd remember it too." And he kind of sat back and he had this grin on his face like he thought he just won the case for the government. And so I said, I totally agree with you. I said, if that had in fact happened, I would remember it very well, which is why I'm wondering why during all of your previous meetings with the government, you failed to mention that to them.
Awesome.
And he just kind of like stood there, and he obviously didn't realize that like we get reports of his interviews with the government that they have to provide to us. And it was like, it turned to this perfect government witness. And, you know, I could, unfortunately, the way that this courtroom was set up terribly, so I couldn't see the jurors while I was questioning, but I could hear the scoffing in the background. And I was like, that's all we need to do. And it's kind of like, I think we just neutralized the house a little bit, which is all the best we could do.
Great.
So those
All right,
are
we
kind
have,
of the theories on a lot of the bad facts.
we have two more for you. Great. Two more for you.
Hi.
Hi.
So my question is, did you ever feel like your side was at a disadvantage because of either the stuff in the media or because of like, you know, dealing with a government that has like unlimited power to sort of do whatever they want? Did you ever feel, or how you dealt with this? I was wondering how you dealt with this at all during the trial.
Yeah, I 100%. And I think as a defendant, you're almost always at a disadvantage. I mean, they win the government and federal criminal trial. I don't know the latest stats, David, but they don't bring cases that they don't think they're going to win. And unfortunately, you know, they win most of them. So I thought we were at a big disadvantage. I do think that, you know, and the media was brutal. The Boston Globe was brutal on this case. But I also think that public sentiment had changed a little bit. You know, these kind of cases, you know, when the Varsity Blues first hit in March 2019, people were in an uproar. I think people have kind of forgotten about it. And I also think that some people, the people who are aware of it, I think we tried to just, again, portray how good these kids were and how they belonged. So we tried to, without actually saying it, tried to distinguish it from the other cases that they had read about in the paper. But we were certainly hoping that these jurors had not, you know, had actually listened to the judge and had not gone back and Googled all the stories about the case, because the Boston Globe stories were very, very prejudicial to us.
I hope they did a series on the acquittal afterwards. I bet you it was like a small little side note on page.
It was so, I mean, somebody told me a saying that's so true. It's like, the more you know about a subject, the less you recognize it when it's written about in the newspapers.
Yeah.
And the Globe especially, like after a day of trial, it was like, it's like, how would you not write about X, right? Like the best thing that happened today, but it was helpful to the defense, so the Globe didn't write about it.
It's amazing, the press coverage in these high profile trials. Most of the defense lawyers that I speak to all say the same thing, which is they read the article the next day and they wonder, like, was that reporter in court? They're only reporting on like the one bad fact that came out instead of the good facts.
It's unbelievable. And I don't really understand it, because I feel like the better story is,
Right.
you know, because it's unusual that, like, you know, we put on a defense, right? We had a weeks long defense case, which a lot of times doesn't happen. That's a better story. But I think also there was a Boston Globe the guy who wrote all the Boston Globe stories was called to testify over the Boston Globe's objection. So I kind of feel like, and his articles had been so against us, I kind of feel like the Globe people felt like they were almost protecting him by taking the government side.
It's one of the reasons I think jurors get attacked so much after these trials is because the public reads these reports.
Yes.
Could a jury acquit based on these facts when those aren't the facts?
I've said that. I've had the same thoughts so many times. That's exactly what happens.
All right, last question. I promise I'd get you out of here by 7. So last question for you.
This will be kind of quick. So with all the texts in the emails, I know you said some of them were pretty bad, but like reading the indictment, some of them seemed pretty bad, but how cherry picked were those and how much did the government really try and focus their theory of the case on that?
So they tried to focus their theory on it a lot. I mean, during their closing, whenever they showed them, the prosecutor would say, like, you could find him guilty on this, like standing alone. This text alone is the evidence of the bribe. All right. Well, I mean, so how cherry picked were they? I mean, we certainly argued they were cherry picked, but I mean, they were just the worst text. So I don't really know how cherry picked they were. They weren't, I'll say this. They were not, now that the case is over, government has no rights of appeal. They were not unfairly cherry picked. They were just really bad. They were really bad text. But what I do think, and this happens in every case, and I really meant this when I said it before, is so the cherry pick thing is, that's arguable. But what is true is that they are texts that, you send and, they're not letters. Nobody sat down and wrote it and then you rewrite it and you read it. It's not like a paper that you hand in class. It's a text message. It takes a second to send. So, I think that's how they're cherry picked. It's not like unfair that, they didn't show all these other texts because then we would have had the right to show those texts. But it's taken out of context when the government flashes them up, and they flash them up on a screen and they got this kind of fancy presentation, with like zooming in and zooming out. It's like, that's not the way the real world works. That's not how people send text messages. So, that's sort of how we tried to rebut that as best we could.
Well, Doug, this has been fantastic. I want to thank you for spending the last hour and a half with us. I learned a lot. The story about showing the wife the check to refresh her recollection, I will steal that in another 1,000%. I loved it. Congratulations on a great trial, great verdict, and thank you again so much for spending time with us.
So my pleasure, and thanks for listening to me, everybody. And I'll just leave you with this before I hang up. Your professor, David Markus, is by far the best point guard in basketball that I've ever played.
Don't give up my secrets. All right, I'm going to find you now.
All right.
Later.
Thanks, everyone.
Bye.
Thanks, David. Take care.